Legally Speaking, with me, Tarun Nangia. Today, I'm touching a very, very sensitive topic. This topic is that many times people turn civil cases into criminal, many times to settle the civil dispute, which we call as foisting of criminal cases in civil matters. This is a very touchy subject because a purely civil matter is given a criminal color. People are threatened with, in a sense, that you will be falsely booked in a criminal case so that the civil case is settled. This is why it's very important. We'll understand how is this done strategically to fix people, if I may call it so. And I have with me somebody who understands this subject very well. May I introduce you to Advocate Vikram Singh. He's an advocate practicing at the Delhi High Court and the other forums and also other courts. He's also associated with law firm Circle of Counsels, primarily an arguing counsel before various forums. Good to see you, Mr. Vikram Singh, and looking forward to some interesting insights from you on this topic.
Thank you, Tarun.
At the outset, if you could explain what is this practice of foisting criminal cases and, in a sense, in civil matters? How do you turn a civil case into criminal, or how do you use this strategy? In about the first 3 minutes, if you could explain this to me.
Now, Tarun, when we talk about foisting of criminal cases in civil matters, we have to understand the objective, why it is done as such. Now, as you know that in our constitution, there is no line which diversifies or distinguish between a civil case or a criminal case. But since inception, litigation is always segregated in civil and criminal as such. Now, what has been lately happening, that this particular aspect has been abused to settle scores. I may put it as it has been an intimidating tool for dispute resolution process, which has been lately used by abusing the process of law as such. Now, what transpires in these cases, that as we are all well aware, though I completely declare this practice as unpardonable and deplorable altogether as such, which is adopted by mischievous litigants, but it has become a contemporary dispute resolution tool, irrespective of the dispute. Marital, name it, you do it, you get settled, as we are all aware. Remember those days of legal terrorism of 498A? People used to run away locking their houses. Call it a property dispute. When we saw the boom of the property in India in 2006 onwards, every contract, if he fails to perform or the other party does not willing to perform because of the increase in an overnight price, then remedy is an FIR next morning. Now it's being used in shareholders and corporations dispute, intra-shareholders dispute, and embarrassingly even in family disputes as well at the same time. I have come across where this where it has been used in, I must say that trademark disputes as well. Now, what has happened lately, that this particular modus operandi is adopted with singular agenda to settle a civil dispute on the terms of the complainant by arm twisting the procedure of criminal law. See, in our country, the procedure of criminal law, investigation and adjudication is anyways very vulnerable to abuse. And once the people realize this, and they don't spare a second thought to adopt this, because it helps them to achieve something which takes number of years, takes the scrutiny of evidence with a person, and that is the reason we are even witnessing this even in IPR disputes as well, where FIRs are becoming very common. This is a derogatory practice. I completely discourage this, and nonetheless, it must be checked by the institution. It is high time, because it does not result into the settlement of a commercial dispute by arm twisting or a civil dispute. It changes the course of life of people as such.
So you mean a mischievous litigant?
Yes.
Or a litigant with a criminal bent of mind. He is using the liberties given in law to turn a civil case by making false criminal cases. Is this strategically people are trapped in criminal cases?
See, to understand this particular aspect, I must say that we have to go into the reasons for this widespread and rampant practice of this nature with litigants as such. See, one of the principal reason that people are adopting this process is the delay in disposal of civil disputes as such. And I attribute the reason for delay in disposal of civil disputes between parties, not that the number of cases are too much in contrast to the judicial officers, but at the same time, the civil procedure itself is so complex that litigants can take enough advantage of the various provisions in the civil procedure code and can litigate till eternity as such. So then what transpires? Let's talk on the more practical aspects of practice of law. That a counsel is unable to comprehend a client that why his matter, which is quite black and white, has been made grey to the optics of the court by the counsel on the other side, and why he is being denied justice for such a prolonged period of time that applications over applications are being put over in civil matters and nobody talks about the suit in the first place as such. So therefore, this idea dawns upon sometimes the practicing counsels that if possibly we can mitigate, manufacture this particular subject matter into the optics of a criminal case, then it may result to a resolution of dispute at the threshold and on the terms of my client as such. So therefore, the first reason that this practice is becoming rampant is the delay in the disposal of civil matters. But without going any further, I'll just give you some illustration that how it is usually done. Now, I have been representing clients pan-India, and the most embarrassing and regrettable aspect has been that, my apology for that, has been that when foreign clients are made victims of this abuse of process, then we as counsels, in spite of our best abilities, cannot make them comprehend what's going on. I'll just illustrate in a very short span something which was a milestone, and I do remember it all the times, that there was an American entity selling scientific instruments, and they had a distributor, and the distributor was with them for a couple of decades. So there was a bridge of trust, there was an element of faith and a social and economic cordial relation with the same. Then what happened that this particular distributor had an inventory of these scientific instruments used in various labs across India. He had obtained them from the American company as such, and he was not able to dispose the particular gear in a stipulated period. Now, what happens in these particular kind of matters? The company will nonetheless, technology is ever evolving, the company will come with a new kind of model, and the company launched a new model particular to that series, and then he realized that the inventory lying with him has rather become impossible to sell now. He was not able to dispose it off within the stipulated time, and by the flux of time, technology evolves. So now the new model has come. What to do? So he simply stated to the company, and it is recorded on the email, that I have this old models. Can you possibly replace those with the new ones? And he's making his agenda, ulterior motive very clear at the threshold. Now, it is important that he's making it abundant clear that what is his objective and recording it at the same time. Now, the company finds it impossible to believe. They are startled. I mean, they call it preposterous, that how can you say, I mean, if we have to do this with you, then we have to do with every other distributor as well. And this is going to be a never-ending cycle, that whenever a new model comes, we have to replace your inventory with the old models. And irrespective of the fact that it costs twice, it cannot be done at any cost. And that was it. The contract had a dispute resolution mechanism in place, as with all international contracts, arbitration. And the reason fraud has been made arbitrable in our country is for this particular reason, that when these two separate legs of litigation, they are positive and they are negative, when they overlap each other, it results into a precarious domain where people get electric shocks as well, because when civil mixes with criminal litigation. So what he does, instead of adopting the dispute resolution process, in spite of the fact that fraud has been made arbitrable, he simply said to construes it that I have been cheated. I was promised orally by the MD. These are the instruments, and what was the value of the instruments purchased was made the quantum of the cheating as such. And it was stated so that because they told me that when time comes, we shall replace the same at the launch of the new model, that contributed as an inducement for me to buy this gear, which I inevitably knew that will be replaced by the new model as such. You see how people craft things as such. So therefore,
without there being any document, they have based on oral complaint, this has been foisted.
That's the beauty of it. You have caught it. The beauty of this is to determine a civil dispute. There is a process. There are framing of issues. Evidence has to be laid. The parties have to go through the rigorous procedure in the court corridor. But all you are expected to do is to be smart enough to define the contract as a tool of inducement, make half-bald allegations, and just initiate the investigation. It is very easy as such. So therefore, people resort to such means that instead of going through the rigor exercise of the court, and also it involves a lot of time, they prefer to resolve the same through this, I must say, that intimidating mode of dispute resolution, or whatever we may call it, arm twisting as such. It is altogether must be condemned by each and every one of us. Now, I will take few minutes to explain how it is done. Now, if you go into this, whenever usually a civil dispute is converted into a criminal case, we can also term it as a false case as well. One must say it is not a false case. I thought it is a criminal case, but I filed a criminal complaint and the police has found substance in it and they are investigating. I totally disagree with this. It is a false case. The subject matter may be common as such to a civil dispute. Now thereafter, if you see that what are the essentials of a contract. Now, to determine, to understand this, we must know that what is the difference between a breach of contract and breach of trust and cheating as such. This is where people take advantage, mischievous litigants. I call them chameleon litigants and such. Once a civil suit is pending, one fine day he wakes up in the morning and decides to change the course of somebody's life. And he says, today I'll make a criminal case out of it. So as you see, a contract involves declarations. It involves representations. It also involves dominion over property. It can be shares or it can be an immovable property or anything in the first place. Now, what is paramount here to be considered as such, that these particular attributes of a contract are also to a great extent attributes and elements of the offense of breach of trust and cheating. I'll show you how in the first place. I'll share it with you right now. That now, as we see that the contract involves an offer. The contract involves a competent person to enter into the same. A contract also involves consideration as well. Now, these aspects of contracts where the rights and the contracts are done for gain, we also don't deny that. So always there is a pecuniary element to each of a contract, whether it's for services, a venture, a purchase of sale and goods. And so how do they twist it in the first place? Now, let's talk about the aspects of breach of trust. Now, entrustment is also a part of the contract, and entrustment is also one of the essential ingredients to commit the offense of breach of trust, because unless I entrust something to someone, how will he misappropriate the same? And when you do the entrustment, it also gives you the dominion over the property as such, which is also one of the essential features of the contract. And therefore, what happens that I often impress this upon the institutions and in courts as well. Normally we have to litigate from both sides as such and defend the client's best. That these days, the tools of cheating are nothing but contracts as such. So now what happens in these cases, the parties are going to say that the acceptance which was made by me was based upon inducement of the averments in the contract. So see how he's linking with this in the first place, that how was I induced? I was induced because of this contract. Now, what was the misrepresentation? This particular reverment which is stated in the contract is not correct. And how you determine it is not correct or incorrect? By the investigation as such. Now, thereafter, what happens? Okay, what is the quantum of the cheating? The quantum of the cheating is the value of the contract in the first place as such. And who are the culprits? The opposite party of the contract, whether he's a plaintiff or the defendant as such. So therefore, you see that in this case, when you enter into a contract, when you make a promise to the other party for delivery of services or of goods or of a joint venture, define your obligations and rights as such, there is always an exchange of trust in a contract and responsibilities and obligations of each parties. Now, these are misconstrued as the elements of breach of trust and also the cheating. Now, this is going to get more and more interesting as such when we talk about cheating. If you see that inducement is one of the most essential ingredients of cheating. Once again, they say, how were you induced? I was induced based on the misrepresentation in the contract. Now, what was the element of deception in the contract? The incorrect observation in the contract was the deception. Even concealment or a very inadvertent omission is construed as deception. Now, what is the loss to you, which is also an element of cheating? What is the wrongful gain to you? What is the wrongful loss to you?
I want to ask you a very interesting aspect here. A lot of people will be interested to know how, when family settlements are delayed between brothers or between brother sisters or kins, how is this tactic of turning civil cases into criminal used to settle the cases? Because this is also seen, if you could share some of those anecdotes with us or some.
Yes. I mean, such matters where civil disputes are tainted and presented as criminal disputes, it hurts more and more when families
because family relations are involved, love is involved.
Now, there has been one instance, not very back, that one brother filed a family partition suit in the case, in the courts as such. He stated that these are the reasons, this is the ancestral property, these are the properties derived by these two brothers. And it is fair. He had the right to ask for a partition of the family property and he went ahead. Now, within a span of fortnight, we realized that we have received a notice from a police station. Now look at the beauty of the story constructed by the other brother. He says that I am the 20% shareholder in the company, which we do not deny. The factory is owned by the company, which is also a matter of record as such. Now what allegation does he make? He simply states that I have been made to resign from this company based on a forced resignation letter. And I never resigned from the directorship of this particular company. And the reason for this conduct, the mens rea attributed to the defendant, that is the person who sought the partition of the family estate, is because he asked for a partition, I denied, henceforth he forged my signature, kicked me out of the company based on a resignation letter as such. And he also made some trivial allegation that the property was rented out, a portion of it as well, without any particular consent from him. He also made allegation that the minutes of this particular meeting also have been forged, where it has been stated that I am resigning from the directorship of the company. Now, the registered office of the company was the residence of the complainant brother. Naturally, all the documents pertaining to the affairs of the company have to be in his custody, including the resolution in which it has been stated so, and including the resignation letter which was actually signed by him. Now, when this particular complaint is filed, how can it be resolved? It can only be resolved by a forensic opinion upon the same. And to have a forensic opinion, you need the original. And who's having the custody of the original? The complainant himself. And he further says that I contributed this much amount in cash and also some in white as such. And for that, they gave me the instrument which also bounced for refund. Where was the checkbook lying? In his office only. Who was the authorized signatory? He was one of the authorized signatories. Look at the beauty of it. And the police starts the proceeding immediately. Now they want to arrest the person. Why? Because they have to recover the original. And this is settled provision of law that custodial interrogation is required to make effective recoveries if they are not being made without the custodial interrogation. Now, the check has defaulted because it was issued and presented without the consent of the other brother as well. So there was not balance enough. So that check also bounced. And at the end of the day, we filed a bail petition. The subject matter was equated with the value of the estate, which was in hundreds of crore. The court was reluctant in granting the anticipatory protection to the accused person, in spite of adequately explaining everything. We went to the Honorable High Court. Now, in these cases, families get so smitten and it sends such shivers to their spine that they are willing to, when it comes to choosing between liberty and your money, what will you choose? Or settling a dispute? Liberty is most precious thing gifted to by the law itself, which guarantee the first thing that the law and the constitution guarantees is liberty. So first he will protect liberty for the sake of his future. And what is the end result? He starts talking about settlement on the terms of the complainant. And it doesn't end there. I'll just take a couple of more seconds. So the only amateur thing he did, as family members got involved. So they said, today we'll settle in evening at 4 p.m. in CP. And there was a settlement deed. Based on the settlement deed, we thought finally we'll get a quashing of the FIR. Before even we could get the quashing of the FIR, he filed another complaint at Mandir Marg police station, stating that the settlement has been coercive and I have been forced to enter into this settlement, and I was beaten and reduced to pulp in the settlement, and he made allegation on the CA who was present as well. Another FIR was registered. So this is very regretful what has been transpiring lately, and it needs to be checked as such, because the advantage which is taken is a very thin line of difference between breach of trust and a breach of contract. It is also very difficult to illustrate to the investigation agencies at least that this is not a criminal case, it is of civil nature, it has emanated from a civil cause of action. The civil cause of action is presented as an action of commission of offense, and clever drafting makes a common person or a amateur investigator confuses him that he's unable to determine, and more so over when the quantum of the money is too high, they are very evasive in this thing and the proceeding starts in our country. So this practice must be curtailed.
I want to understand from you why in India this practice or this malpractice of turning civil disputes criminal and then threatening the other party with loss of liberty, as you know, I'll file a false criminal case, you'll be in jail, so settle this with me on my terms. Why is this malpractice gaining ground? And what are the dangers because of it? But first, why is this malpractice gaining ground?
See, the reason it is gaining ground, as I said, one of the reason was the slow process of disposal of civil matters. One of the prominent reasons is in our country, the investigation begins with incarceration. Momentarily, there is a criminal complaint. There is a knee-jerk reaction by the accused person as such. And investigation agencies are unable to distinguish between the aspects what constitutes a civil dispute and what constitutes a criminal dispute as such. Now, another thing which mitigates it further is the institutional insensitivity towards the same. Now, there are two kinds of ways to convert a civil into a criminal. One, where a civil matter is pending. After some delay, maybe of 1 year, parties have done this after years of delay, you file a criminal case on the same. That is one way people do it. Another way people do it, who are habitual offender, are such, and they know how to abuse the process very well, is that there is a civil dispute, but they will not adopt the civil remedy. The first threshold and the first motion which comes into public domain is a criminal complaint as such. And moreover, as I stated some time back, one of the primary reasons that this practice has become so prevalent and embarrassingly naked and shameful on the horizons of dispute resolution process is that it ensures that the matter gets settled all times, and it increases the likelihood of settlement between the parties substantially as such. So these are And apart from that, one thing I would also seek your liberty to say the same, that things are not getting corrected in my limited sense of understanding. As we know that in India, the trial itself is a tyranny. It goes on, and I stated some moments back that the criminal justice system is very vulnerable for abuse in the first place. Now, what has lately happened that what we are talking of conversion of civil disputes into criminal proceedings, usually all such civil disputes, as we know from adjudication, are economic and financial in nature. A contract usually has an element of consideration or elements of goods and pecuniary aspect to it all the time as such. They determine the rights and obligation. Now what happens into here, that if by chance that false complaint converts into a criminal case, then the misery of the family and the person does not even end there. What happens now? That momentarily there is an economic offense registered or a financial crime registered. Not just that, an innocent person who has been framed in a false case will join the investigation with the local investigation agency before he realizes another agency comes, which is maybe an SFIO or maybe ED. Because what the trend we have seen lately, that if there is a crime and there are proceeds of the crime as such, here there is an economic offense, naturally it will have proceeds as well. So the person, just in 4 words, he says, what have I done to deserve this, Vikram?
Basically, for nothing, he can land up in jail. Absolutely for nothing.
Correct. And he has to go across many investigation agencies in the first place. Previously, he had just had to explain the local investigation agency. Now he's expected to explain the entire matrix to another investigation agency who's investigating a separate leg of offense, which emanates from there. And
Even
it's treated as a predicate offense.
it could be the local thana, then it could be SFIO, then it could be ED. So in that
Correct.
process, he's ruined.
Very correct as such. I mean, with due respect, you know the insensitivity of the investigation agencies lately as such. You know that investigation officers are not well trained to understand financial crimes. Financial crimes.
But tell me, when the local thana is reported, is the inspector or the sub-inspector there equipped to understand the complexity of financial crimes?
Usually, I have joined investigations in many states as such, barring few states like Karnataka, Maharashtra, and Delhi. They too, even these 3 states struggle at times to understand
It's a complex matter.
how to distinguish between a civil and a criminal matter as such. See, it gets very confusing. You cannot deny there was a transaction, correct? You cannot deny that these were the parties who entered into the transaction. You cannot deny the execution of the contract. You cannot deny the exchange of money and the property or the dominion over the same as such. You also cannot deny that there is a breach, whether that breach is of contract is of or of trust. That's the only thing which has to be ascertained as such. So it is not that everybody is motivated to do the same. In spite of their best efforts, they are not able to distinguish.
I want to ask you something. Sometimes the police is duty bound to investigate if a complaint has come to them. So you feel even their hands are tied in many cases where, there is a complaint, they have to investigate.
See, this is how sometimes law is abused. Now, the law is very clear. Whenever you report a cognizable offense by the Honorable Apex Court Lalita Kumari judgment, you have to register an FIR. Correct? But we have to understand that is our society and country as such is having so many soothsayers that they will just stop short of a false complaint to set their wrong right. No, the answer is this. Once there is a cognizable offense, I always recommend that the police must indulge in some kind of preliminary inquiry in the first place. There are safeguards in Delhi and directions by senior police officers to the economic offense wing that do not register direct FIRs. But what is the result, gentlemen? The result is this, the statistics will shock you. 25 to 35% of economic financial crime cases are settled even before registration of FIR. The very thought that a notice has come from police station is sufficient enough to make the whole family skip sleep that night.
So it is used as a coercive method for settlement of civil disputes.
Precisely. And the factum of joining the investigation, which is the mandate of law as well, you have to cooperate, you have to go, you have to join the investigation. The atmosphere, ominous atmosphere in a police station, in an economic offense wing, where the person is not even sometimes permitted to be represented through counsel as such. He has to go personally to explain the circumstances, and he's not the right mind, and he's not in the right frame of mind as well, not having the competence to explain the same to the investigation officer. And the deficiency of a good counsel besides him results in miscarriage of justice at the very threshold. And once the machinery of criminal justice system has been set in motion, it takes time.
So we almost out of time, but today from Advocate Vikram Singh, we could understand very interestingly how falsely people are booked in criminal cases by scheming to settle a civil dispute. But this is not the end of it. We'll be having 2 more parts on the same subject with many more anecdotes from different sectors. How stratagems are used to book innocent people in false cases so that the civil dispute is settled. How this lacuna in law can be addressed. Are the investigation agencies starting from the local police station ready to in a sense investigate these allegations? Is a PE like the CBI does the way forward, that their prelim investigation has to be made before this PE is turned into a FIR? All of this merits discussion and inputs. I am sure that Advocate Vikram Singh will be kind enough to give us time next time to explain this further. A lot many people would be interested in knowing, because this involves us all. There'll be many people who are suffering this who would be watching this today. And I think this will lead to some greater sensitization even in the forces, which is the police force and the courts, as to why somebody who is actually aggrieved is being booked in a criminal case. Now he has to defend himself. So his psychological condition is also in some kind of what is he going through? How is this threat used to settle cases? All of this in the upcoming part 2. But I would like to thank Advocate Vikram Singh for giving us time and sharing all of this. And thank you, viewers, for joining in. Thank you so very much.
Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.